Segundo, hay servicios curativos en salud que no estaban previstos en el plan de beneficios, que pueden ser muy costosos, que deben ser financiados en un caso individual si el juez protege, pero que orientan recursos hacia prioridades, entre comillas, judicialmente determinadas, que quizás afectan, o seguramente afectan, a otras personas que no tienen ni idea de ese caso y no saben que a medida que se deciden esos casos, los recursos de la salud se están yendo hacia atender unos servicios que no son los servicios que esas otras personas necesitan. Entonces, por mencionar un ejemplo, se presentó un gran debate en Colombia en torno a si la protección individual caso por caso con este esquema estaba distorsionando las prioridades de salud y si lo estaba haciendo de manera irracional, y cómo darle voz a las personas más pobres que ni siquiera saben que pueden acudir a la tutela para poder recibir protección. Eso es lo que llevó a la Corte en últimas, esas y otras razones, a proferir la sentencia T-760, que además de proteger en los casos individuales a quienes presentaron la acción de tutela y de mantener la jurisprudencia de protección en casos individuales, busca introducir una aproximación más sistémica para que haya una asignación, una definición de prioridades que cobijen toda la complejidad del problema y reconozca que es inevitable que haya límites, ¿no es cierto? La Corte, sin embargo, no intentó fijar esas prioridades. Yo creo que sería un efecto aún peor que la Corte sea la que empiece a rediseñar el post y a decir qué es lo que es prioritario en la salud. Por eso hubo cierta prudencia. Dio esa orden, pero digo, bueno, es el regulador a través de procesos participativos y insumos racionales el que debe tomar esa determinación, solamente con unos plazos y la necesidad de presentar informes.
I could possibly just pick up on the one aspect of what was called negative consequences. And I think it's interesting to note that Judge Sachs, in a PE municipality case, showed a serious concern about what would happen to people who were potentially evicted. And he stated that there was a particularly activist role for the court to play to making investigations about what may happen to them. So he stated quite expressly that before actually ordering an eviction, he would want to know that there was some type of mediation taking place. And that, in many ways, is probably the high point of the court in South Africa, looking towards an activist role for the court in seeking mediation. Since then, the court's possibly gone back slightly on that question of mediation, but in eviction cases, it's actually held that there has to be some type of engagement between the evicting party and the potential evictee before there's going to be any eviction. And that may be stepping back a slight bit from the activist role that Judge Sachs called for, but there's clearly an engagement requirement from our courts. On the issue of corruption, just briefly, I think that it's an area where there is a call for far greater political will to be able to do the country. And I think that that's something that we hope to see in the years to come.
In the delivery of in the implementation of court's orders on social economic rights is beyond, I don't think there's space for judicial intervention and anxiety around that, because that would be, that's really the responsibility of the executive. It's a political and social responsibility to ensure that those rights are achieved. And one of the things that has worked very well with us over the last few years in India has been the notion of people's audits and the right to information legislation. Because on the one hand, there's the right to information legislation, which is really very, it's very strong. It enables you to ask virtually anything from government and get any document. But the idea of people's audits, they call it social audit, has got more and more internalized, which is actually organizing hearings around issues affecting people. So, if you, for instance, are engaged in a public work, you organize a social audit. Somebody gets the papers out which shows who was paid what wages according to government, and who was given what contract and on what terms. And then you call a meeting of the affected people and you read out, explain, and when you read out, say, the list of people who are supposed to have got wages, somebody says, oh, that person was dead 3 years ago, how is his name there? That person's migrated somewhere. And so then you discover that there is a fudging of those records and corruption is exposed. And that acts as a pressure. So, I mean, I think that the fight against corruption will ultimately be fought when people use their democratic rights effectively. That is not what courts are going to do.
Yes, and I'm interested to hear comments about the role of third parties, amicus, civil society in the structural cases that you've been talking about. We've heard a lot today about the importance of allies and other actors, particularly in structural claims. I wondered if what is available to you as courts to ensure that the groups that need to be there at the hearing of these important cases are actually able to get there. Have you, for example, had cases where you're concerned that the most disadvantaged groups who might be affected by the policy that's been reviewed aren't present, and do you have available to you any way of saying, here are, ordering the government to provide resources to ensure that that group is also heard? Are there issues of costs? For example, would you ever require the government to pay the costs of intervening groups in order for them to be able to provide you with the evidence that you may need to consider some of the broader implications of cases? So the broader issue of access to justice, I'd be interested in hearing comments on.